This is Amendment 5, a clause called the Due Process Clause. I think last time I read is a common interpretation, but I'm going to separate this recording just for this clause. So we're going to start over again. Common interpretation, the Fifth Amendment Due Process Clause by Roger E. Fairfax and John C. Harrison. I'm not sure, okay? But anyway, let's start this from this clause. The principle that the government should be limited in how it makes decisions detrimental to private people is well old. In the Anglo-American law, the Magna Carta, Statement to Subject Rights instituted by King John of England in 1215, became well known over the centuries. Chapter 39 provided that no freeman shall be arrested or imprisoned except by lawful judgment of the peers or by the law of the land. This language and its subsequent refinements give rise to the concept of due process for law, and influence the drafters of the Due Process Clause of the Fifth Amendment to the United States Constitution. Although the Fifth Amendment Due Process Clause is brief, important parts of the Supreme Court's constitutional doctrine resonate. At the most general level, the clause reiterates the principle of the rule of law. The government must act in accordance with the legal rules and not contrary to them. A more specific application of the clause is the doctrine today called procedural due process, which concerns the fairness and lawfulness of decision-making methods used by the courts and executive. Governmental actors violate due process when they frustrate the fairness of proceedings. That is when a prosecutor fails to disclose evidence to a criminal defendant that is that they may be innocent of the crime, or when a judge is biased against a criminal defendant or the party in a civil action. Likewise, a fair notice and the opportunity to be heard are due process requirements in criminal, civil, and other proceedings. The court also attributes to the Due Process Clause a notice requirement that apply to statutes rather than executive and judicial action. A statute that is extremely unclear can be, in the court's terms, void for weakness. This is because it does not give people sufficient or fair notice of what the law requires. Another more controversial application of the clause is the doctrine today called substantive due process, which extends beyond the method government institutions use to make decisions and places substantive limits on governmental authority. There are long-standing debates regarding whether the text and history of the Fifth Amendment Due Process Clause support the concept of substantive due process that has been embraced by most of the current Supreme Court justices in varying degrees. These differences of opinion necessarily are informed by interpretations of meaning and the relevance of the historical evidence, meaning of the words used by the framers in the clause and whose understanding of that meaning is relevant, and more fundamental views of whether the meaning of the Constitution was fixed when written or can change over time. Despite the lack of consensus over the scope of a substantive due process, the meaning of the Fifth Amendment Due Process Clause in the procedural context is relatively settled as a matter for Supreme Court jurisprudence. Although both the Fifth and the 14th Amendments have a due process clause, the Fifth Amendment Due Process Clause constraining the authority of the federal government is the identical due process clause of the 14th Amendment constraining only state governments. There is only one equal protection clause. It applies only to the states. The court and also found that the due process clause of the Fifth Amendment imposes on the federal government restrictions that are almost identical to those imposed on the states by the equal protection clause of the 14th Amendment. Mander's debate. The first perspective is, let's be clear, recognizing the weakness doctrine of the Fifth Amendment's Due Process Clause by Roger A. Fairfax. The Fifth Amendment Due Process Clause does as much work as any provision in the Constitution. The clause requires fundamental procedural fairness for those facing the deprivation of life, liberty, or property. The clause also has been interpreted to place substantive limits on governmental authority, meaning that there are certain fundamental freedoms the government cannot take it away, regardless of the procedure, for example, notice and hearing before a judge that it employs. Under this view, the clause addresses not only the fairness and availability for procedures the government provides, but also speaks to what the government may forbid or require. As discussed in the joint essay, the nature and extent of substantive due process has long been a matter of intense debate in the United States. However, while jurists and scholars tend to focus on procedural due process and substantive due process, another important aspect of the clause deserves greater attention. The Fifth Amendment due process clause is also understood to require fair notice. As noted in the joint essay, the due process requirement of fair notice applies not only to notice to parties regarding the availability or pendency of formal proceedings, but also to situations when statutes and sanctions are not sufficiently clear to provide proper notice to those governed by their terms. As the Supreme Court noted in its recent decision in Johnson v. United States 2015, the weakness doctrine of the Due Process Clause projects against a criminal law so weak that it fails to give ordinary people fair notice of conduct it punishes, or so standardized that it invites arbitrary enforcement. In Johnson, the court addresses a part of the key federal criminal sentencing statute, which required someone convicted for crime to serve a long prison sentence if they had previously been convicted for 3 or more violent felonies. The court held that the definition of violent felony was ambiguous. It was unclear whether crimes like attempted burglary or possessing an illegal weapon could count as violent felonies. And thus, the law did not provide proper notice to defendants who might be sentenced more harshly under the law. For this reason, the court concluded that it violated the Fifth Amendment due process clause. However, one justice in that case criticized the clause's weakness doctrine, suggesting that its evolution was similar to that for substantive due process and noting the court's historical use of the weakness doctrine as a basis for striking down a wide variety of laws regulating both social and economic activities. Nevertheless, whether or not one's reading of the clause supports invalidation of a statute on weakness grounds, it is safe to say that the weakness doctrine is well settled as a feature of the Fifth Amendment due process clause in the Supreme Court's jurisprudence. Despite the attention paid to procedural due process and substantive due process, the weakness doctrine is essential to the due process clause's place in constitutional metrics. It is also a significant constraint on government action and therefore merits greater recognition. The next perspective. Okay. Does the due process clause say more than what goes without saying? By John G. Harrison. The least controversial aspect of the Fifth Amendment due process clause is also least interesting. The clause may reiterate the rule of law itself with respect to the ways in which decisions are made. Whatever else it means, due process law very likely means the government must follow procedure called for by the applicable law, other than the due process clause itself. For example, if an applicable statute says that the court's appeals must hear oral arguments in certain cases, it may not limit the parties to written submissions. While a promise by King John to respect the rule of law may have been significant in 1215 when an ancestor of the due process clause first appeared in Magna Carta in our legal system with a written constitution, it simply assumes that the executive and the courts must operate in accordance with the legal rules. Whether due process clause ends any procedural requirements of its own is more doubtful, but it may. On the one hand, the due process law is sometimes used to mean something more than compliance with whatever procedural rules the law contains. On the other hand, constitutional drafters who want to make sure that the government decisions were subject to procedural requirements might have sought such a weak provision to be too unclear to impose sufficient specific requirements on top of the procedural rules contained in other laws. The history of the Due Process Clause suggests another reading, one that was very important for many decades, but that has largely dropped out of sight. According to this interpretation, due process law means specifically the procedures that are used by and only by the courts. Courts decide according to existing law after giving part notice and hearing. According to this interpretation, the clause is a part of the separation of powers. It absolutely forbids the executive and the legislature from doing what the courts want to do, which is to deprive people of life, liberty, or property. As a historical matter, this reading was mainly deployed against legislation that directly altered property rights by pure force of law, like statutes canceling corporate charters previously granted, while this reading played a very important role in constitutional history. It is subject to the objection that it just reiterates the separation of power itself. There are functions that only courts may perform. The separation of powers keeps the legislature and the executive from performing those functions. This reading of the Due Process Clause, that is for analogous provisions in state constitutions, was a textual foundation of the 19th century doctrine of vested rights, according to which private property and private rights created by contracts were protected against legislative alteration. Substantive due process, it is currently understood, meaning that the government may not violate certain fundamental rights that do not appear elsewhere in the Constitution, and may not draw certain classifications, for instance, based on race or sex, without especially strong justification. It's difficult to justify in light of the text and history of the Fifth Amendment. The text is at best a very indirect way of saying that government must be reasonable, that unidentified but important interests are protected to some substantial but unidentified extent, and that some unidentified grounds for distinction must have especially strong justification. If the drafter wanted to convey any of those messages, it would have done so much more openly and in much greater detail. The history does not suggest that the due process clause of the Fifth Amendment was anything like as important or ambitious as the current substantive due process doctrine makes it. Okay, that's the due process.